Good afternoon, Washington, and congratulations on making it to the national finals. And congratulations to you, to your teachers or coaches, and to your family as well. I'm Ed Murphy. I'm a Superior Court judge in Tacoma, Washington, and I really look forward to hearing your presentation today.
And I am Edward Volpe. I'm an attorney in Denver, Colorado. I've been working with this program for a great many years. I love to see you young people coming forward and demonstrating the kind of knowledge that you gain in this program. It's a great benefit to you, to your family, and to your society that you now know more than most of the voting public of the nation. Thank you for your hard work. I look forward to your comments.
Hello, students. My name is Caitlin Johnston. I am an attorney in New York City. And back when I was in high school in Indiana, I was also a We the People participant, but I never made it to finals. So you have already bested me. Congratulations on being here and best of luck.
I would ask the students to introduce themselves and their teacher or coach.
Good afternoon, judges. I'm Caroline Quevedo. My favorite Supreme Court justice is Sandra Day O'Connor because she overcame adversity and paved the way as the first female Supreme Court justice, and also because she's from my hometown of El Paso, Texas.
Hello, my name is Marie Vandenbosch, and my favorite Supreme Court justice is Earl Warren for his outstanding leadership in unifying the court to advance the social progress of our nation.
Hello, my name is Cami Fairbanks, and my favorite Supreme Court justice is Louis Brandeis for being the people's lawyer and for his views on the fundamental right to privacy.
Hello, I'm Bailey McAllister, and my favorite Supreme Court justice is Ruth Bader Ginsburg for her grit and fight against gender discrimination. On behalf of the Tahoma School District, our advisor Gretchen Wolfing, the state of Washington, and Unit 5, we thank you for judging us today.
Well, as you know, we're on Unit 5, and the question is question number 2. Thomas Jefferson, in a letter to James Madison, wrote, "A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference." Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? What are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
Freedom is independence of the compulsory will of another. It is the one sole, original, inborn right belonging to every man in virtue of his humanity. Immanuel Kant.
We agree with Thomas Jefferson's assertion that all people are entitled to a Bill of Rights against their government. The Declaration of Independence holds that all individuals are endowed with the unalienable rights to life, liberty, and the pursuit of happiness, and that the purpose of government is to secure those rights.
A Bill of Rights holds the government to this standard by enumerating freedoms that no just government may refuse. For example, the United States Bill of Rights is used by the Supreme Court to secure individual rights, such as through the application of the First Amendment to protect controversial symbolic speech in Texas v. Johnston, 1989.
Governments that do not adhere to a Bill of Rights may neglect their ultimate purpose to secure the rights of the people. In Myanmar, for instance, the unconstrained government has persecuted and killed Rohingya Muslims since 2016 and used deadly force to subdue recent protests, infringing the rights to freedom of religion and speech.
All people are entitled to a Bill of Rights, but the enumeration of these rights is not sufficient. Despite the guarantees of free speech in the 1982 Chinese Constitution, the government is notorious for silencing protests and heavily censoring the media.
It is the responsibility of a just government to actively defend the contents of its Bill of Rights in order to prevent the deterioration of a balanced society.
A national Bill of Rights is advantageous, as it is the foundation for rights in all states, but it has disadvantages for which the state Bill of Rights compensate. The national and state roles in the protection of rights were outlined in Traylor v. State, 1992, where the federal constitution was equated to, quote, the floor of basic freedoms, and the state constitution, the ceiling.
It is beneficial for rights to be secured on the national level, as this sets a standard from which no states may deviate. Through the selective incorporation process, essential liberties in the National Bill of Rights have been extended to the states, such as the freedom of speech in Gitlow v. New York, 1925.
However, when compared to state bills of rights, the Constitution's first 10 amendments merely scratch the surface of the extensive rights that serve to secure individual liberty. For example, the right to privacy is not enumerated in the national Constitution, but can be found in Section 7 of the Washington Declaration of Rights, as well as in 9 other state constitutions.
Though state bills of rights account for the shortcomings of the National Bill of Rights, the inconsistent protections between state bills of rights illustrate the disadvantage of weak federal standards.
While the National Bill of Rights fails to acknowledge certain freedoms, it plays the crucial role of laying the groundwork of basic rights upon which the state bills of rights can further expand.
Positive and negative rights both aim to serve the interests of the people, but negative rights prevent government action, whereas positive rights obligate the government to take action.
Negative rights are more important to the preservation of liberty, as reflected in John Stuart Mill's assertion that liberty is promoted through the limitation of government power. The First Amendment's negative rights protecting freedom of expression are a cornerstone of American liberty, as these rights prohibit the government from obstructing the open exchange of ideas.
The significance of these negative protections was illustrated in Near v. Minnesota 1931, when the court struck down a prior restraint statute that allowed the government to censor a publication in advance, limiting the government's ability to interfere with liberty in the press.
Positive rights, though beneficial, can often come into conflict with Mill's definition of liberty. For instance, an Oregon statute that sought to enforce the positive right to public education through compulsory public school attendance was struck down in Pierce v. Society of Sisters, 1925, where it was recognized as a violation of educational liberty.
In order to secure individual liberty, a government must not refuse the enumeration of the negative rights to which all people are entitled.
All right. I'd ask you to put aside any notes you may have out, and we're going to start the follow-up questions. What limits, if any, should be placed on individual rights listed in the Bill of Rights, such as freedom of speech?
I agree with the limits placed on speech that occurred in the court case Brandenburg v. Ohio through the Brandenburg test, which prevents any speech that is likely to incite imminent lawless action.
In accordance to the Brandenburg ruling, the court has also cited multiple restrictions on freedom of speech in Schenck v. the United States, in which the court determined that free speech can be limited when it presents a clear and imminent danger.
I would also argue that time, place, and manner restrictions are appropriate restrictions on freedom of expression. For example, in Rock v. Ward against racism, a rock concert held in a resident area was restricted based on noise because it violated the rights of the homeowners in the area. And this was a constitutional limitation of freedom of expression.
Additionally, freedom of speech may be limited in a school setting. This was established through Morse v. Frederick, as well as Bethel School District v. Fraser. This is because schools serve as en locus parentis and serve to look out for the best interests of students. So speech promoting drug use or inappropriate behavior may be limited in this situation, in addition to speech that distracts from the learning environment.
May positive rights and negative rights come into conflict with regard to the obligation of the individual to the government versus the obligation of the government to the individual? I'm thinking of the military draft.
Yes, so positive and rights with regards to individuals may come into conflict. With regards to the military, the draft would be a conflict of positive rights and negative rights. The negative rights of the people to be let alone from the military and to serve their pursuit of happiness within their own life, and the government's obligation to protect this country.
Another instance where positive rights and negative rights have come into conflict was in the case Jacobson v. Massachusetts, where a pastor claimed that it was a violation of his religious freedom for the state of Massachusetts to force a mandatory smallpox vaccination upon him. However, the negative right to freedom of religion was prioritized over the positive right to public health and safety in order to protect the common good.
In addition, another positive right that can place a burden on citizens is the positive right to Social Security and Medicare. This right protects Social Security protects the positive rights of elderly individuals by providing retirement benefits. However, this requires increased taxing from the federal government, which places a burden on other individuals and creates a conflict between positive and negative rights.
What circumstances, if any, could cause a person to lose the rights that they are granted under either the Bill of Rights or elsewhere in the Constitution?
So if someone has committed a felony crime and is then convicted and prosecuted for that crime, they may lose their right to vote. In Washington, however, this right is not completely lost. As in Washington state, felons do not completely lose their right to vote. They still have the right to vote, even regardless of withstanding fines.
In addition, in Reynolds v. United States, the Supreme Court ruled that the free exercise of religion is not protected in situations where people's actions are violating the law.
Can you say more about that?
In this particular case, the Supreme Court was ruling on a situation in which an individual practiced bigamy on religious grounds, and since this was a violation of the law, this was not protected by the Free Exercise Clause of the First Amendment.
Further expand on what my colleague Caroline had mentioned about Reynolds, the federal government actually suspended funds from the Mormon Church regarding this case because they had violated a Utah law regarding bigamy. So they lost their particular rights to exercise those funds.
Another situation in which an individual might lose the rights granted to them through the Constitution and the Bill of Rights is if they are committing a crime or have illegal items in plain view. This was established in Maryland v. Macon, in which the warrant requirements can be waived if illegal items are in plain view of a police officer. Additionally, Payton v. New York established that probable cause and exigent circumstances may also justify a violation of your Fourth Amendment rights.
Thank you.
Are there any rights, either positive or negative, that are better addressed at a national level rather than at the state level?
I would argue that the right to privacy would be better addressed on a national level rather than a state level. Currently, Washington state identifies privacy as in Article 1, Section 7 of the Washington State Constitution, but this is not found in our national constitution. Although identified in Griswold v. Connecticut as a fundamental right, the right to privacy is often neglected within national conversations.
To expand on what my colleague Cami has said, I believe that privacy needs to be better addressed on a national level because currently privacy is not addressed on a national level. It's only implied through our Bill of Rights and the penumbra of the Constitution. And because of this, acts such as the Patriot Act were passed, which violate people's Fourth Amendment rights. Section 215 of the Patriot Act allowed warrantless searches, and the Patriot Act overall enabled the NSA to conduct secret court cases and gag orders and really infringed upon people's individual liberty. This is something that the states could not protect against, even those states which outlined privacy in their state Bill of Rights and Constitution.
To expand on what my colleague Caroline mentioned, it is really important that the federal government issues more comprehensive protections of privacy on the federal level, because currently there are a lot of disparities among the states. For example, Article 1, Section 7 of the Washington State Constitution protects against privacy and has even been used in cases such as State v. Boland to protect trash in Washington state. However, Wyoming does not have very strong protections over privacy, and the employers in the state of Wyoming can force the employees to give up their social media passwords, which is a very evident breach of privacy.
I would also argue that the positive right to public education should be addressed on the federal level. Currently, the federal government only funds 8% of education throughout the states, and I believe that the federal government should play a larger role in funding education, especially in low-income school districts, as this would protect against income inequality in education throughout all the states, which is difficult to address on the state level.
You've addressed the right to privacy. To what extent do you think that the law should adapt the concept of privacy to our new cyber world where we're all on the computer? Should the federal government or the state government step in to try and protect the right of users of the cyber world?
They were saved by the bell, Judge Volpe.
Well, I'm sure your answer would have been brilliant. I will score you accordingly.
Everybody take a deep breath and relax. You're through with this round. So congratulations. I want to compliment you on the presentation, both the 4-minute presentation and then your ability to answer the questions. I especially liked the pace at which you spoke. It was not rushed. You did pack a lot of information into that time period, but you did it in a manner that was easy for us to follow and keep track of. And you all contributed equally throughout these conversations. You put a lot of citations in there, a lot of cases that you seem to have at your fingertips and with knowledge and understanding of. And so I really want to commend you for the work that you've put in, commend your coaches and teachers, and a job well done.
I too thought you did a good job. I thought you handled my question on the draft extremely well. This is a conflict of the two important principles that are the foundation of our government. One, of course, is self-realization, the ability to pursue your life, liberty, and the pursuit of happiness on your own, and yet the common good, without which we probably wouldn't have a lot of individual rights. And so therefore, the government may call upon individuals to serve the common good, even at the expense of their individual rights. And I can think of other examples, but that's a good one, wherein we ask people to forfeit some rights and to go into public service. Another example, of course, is jury trials. You're being asked to leave your work, leave your home, whatever the case is, and you go into the courtroom to serve our system of justice as private citizens, which is an extremely important aspect of our justice system. Good on the limitations of speech. I thought it was very interesting that you got into limitations of speech in relation to schools. You came up with Morse v. Frederick and the punishment of the student for his sign, "Bong hits for Jesus" at a public parade. Very interesting case. Jacobson versus Massachusetts is another example of how we might all have to give up a little bit of freedom. In other words, the right to refuse a vaccination if we want to go back to school or otherwise participate in social events. And I thought that was good. Your reference to Social Security, where we tax the working population to try and support those who are no longer capable of working or choose not to work. But that again is something that taxes the individual for the common good. We don't want people after their career is over to starve to death. And we are organizing our laws in such a way that they don't have that problem. Can we ban private activities? Certainly Reynolds versus US is a good example of that. It was upheld in the decision of the Supreme Court in the late 1890s. And at the same time, you recognize further enumerated rights with regard to privacy. You cited the Texas v. Johnston case, which goes along with Griswold v. Connecticut, saying the state has no business in the private bedroom. Whatever one chooses to do there, be it the marital couple in Griswold or the same-sex couple in Texas v. Johnston, the state has no ability to address those issues. Those are private decisions that must be left to the private individuals. And you are correct with regard to the fact that you can lose rights if you commit crimes. You could have gone on for a long time with respect to that. There's the issue of whether or not the rights can be restored after you're out of prison. But I'm going to leave that up to the next judge to talk about. Thank you for your presentation today. Thank you for your hard work.
Yes, I will keep my feedback short because these folks, I co-sign the feedback as well. You guys did a great job, especially in response to my question, which I deliberately let hang there for a minute after the first answer was given because it was a good answer. But there was more you could have done with it. And I appreciated that you offered us a range of answers that spanned states' consideration of this with the right to vote for felons. I enjoyed hearing about what Washington's position on that is, and then the First Amendment, and then the Fourth Amendment. So it was a good way to show your range in response to that question. And it's the really good teams don't stop at one answer, even if the first person nails it. You just find another way to show the judges something else that the panel knows about. So I thought you did a great job with that. And I was thinking for the last question, we were talking about privacy should be a national law, but I'm thinking as you're arguing, well, why not education though? What's the difference between, you know, privacy and education? So a little bit more of the why is it broken? If you know, or if you can cite some examples for, you know, a state treating two states treating something differently. But then somebody chimed in with education and I was like, okay, well, there we go. So, so great job. I really enjoyed the presentation.